Hi everyone, I'm Mrs. A. Prasanna, Assistant Professor of Chemistry, V.V.Vanniaperumal College for Women, Virudhunagar. In this video, Introduction to Forensic Science, I am going to discuss expert evidence. In crime investigation, witness will be allowed to testify orally and produce documents in order to establish facts, but he may not get an opportunity to express his opinion on it. Opinion can be an inference from observed facts expressed by experts of competence in that area, thus becomes paramount in establishing facts in issue or relevant facts. Let us see about who can act as expert according to forensic science. Ideally, the judge or jury is supposed to give opinion, but exceptions exist. If it were to assist in determining a particular fact, an individual well-versed in that field may be worth consulting to arrive at a better inference. So, an expert is a person who has specialized knowledge on any matter by reason of his special study or experience. English courts have acted on the opinion of experts from the very early times. Archibald Smeaton, a famous engineer, was called to give his opinion in structural mishap in a harbour. Let me point out few functions of an expert. In V. Edinburgh Magistrates, the functions of an expert is stated as follows. According to that magistrates, an expert's duty is to furnish the judge or jury with the necessary scientific criteria for testing the accuracy of their conclusions, so as to enable the judge or jury to form their own independent judgment by application of these criteria to the facts proved in evidence. Let me talk about competency of expert. Competency of an expert is a unique combination of his knowledge, skill, and experience, but in a court's perspective, usually it is decided as follows. It is the duty of the judge to decide whether the skill of any person in the matter on which evidence of his opinion offered is sufficient to entitle him to be considered an expert, and therefore competent to give evidence. Let us see about expert evidence. The facts upon which an expert's opinion is based must be proved by admissible evidence, and he should be asked in his reasoning what those facts are. The evidence so provided becomes expert evidence, and the expert indirectly becomes a technical witness to the case. However, before an expert may testify, the judge must first determine whether the witness is qualified as an expert in a particular field by knowledge, skill, experience, training, or education. That the testimony will help the jury arrive at the truth. There are various experts in forensic science. Different kinds of experts, they render their service. They are as follows: medical examiner, document examiner, fingerprint expert, skid mark expert, speed expert, and accident reconstructionist, bookmaking, narcotics, and other specific types of crimes experts, criminalist or forensic scientist, DNA expert, pattern expert, psychologist, psychiatrist, polygraph examiner, voice print expert, photographer. So it's a vast field. Depending upon the expertise, different experts are there. Let me talk about relevancy of expert evidence. The general rule is that experts' opinions are relevant but not conclusive. In contemplation of which the following are reasons on its relevancy. Your court is not bound to act on the evidence of an expert. Sufficient reasons must be given by the expert. In Solicitor General V.V.Vanniaperumal, on a charge of selling government arrack without license, the preventive officer's evidence was rejected as he failed to give reasons as to how he came to his opinion. So the expert should give sufficient reason for his opinion. The difficulty of assessment of expert evidence. Let us see that one. The court has no means of qualitatively and quantitatively verifying the conclusions of the witness. If there is conflicting testimony, the court may have to decide on doubtful matters such as the reputations and experience of the rival expert. Thus, the expert's opinion is relevant but may not be conclusive. It was considered as a relevant fact to be taken into account in forming the opinion of courts. Let me conclude this video, that is experts evidence. An expert witness is a person skilled in some art, trade, science and profession. An expert must have either knowledge, skill, experience, training or education that is beyond and above that of the average person. In this respect, an expert is in a position to assist the jury because they do not have the background to this type of work. Expert opinion are relevant but not conclusive. Experts may be called upon by both sides to a case. A mere handwriting is not at all direct evidence to convict the accused, but is an assisting component. Every expert who gives opinion must give logical reasoning or grounds behind his finding for the courts to accept it as evidence. So let me stop here. Thank you.